by the Constituent Assembly only for defining Indian citizenship, and the crucial words are at the commencement of the constitutions. This definition of citizenship was necessary in order to define eligible voters to elect a new parliament. That was the crucial thing, my lords. At that point of time, we were a new nation. We were a nation that had suffered a partition. There was a question as to who was an Indian and who was not an Indian. And therefore, the constitutional architecture of Part 2 was that we would define only at the commencement who is a citizen. Thereafter, that last one, Article 11, left the field open to Parliament to do what it thought fit in the circumstances. The situation also had to take into account migrations due to partition. The Constituent Assembly therefore limited their definition for the commencement and give full powers to Parliament to define citizenship, grant it, or take it away. The first Parliament therefore enacted the Citizenship Act 1955 to regulate citizenship. Well, it's just a couple of dates. Firstly, the date of 19th of July 1948. Why was it chosen? If your lordships were to go to volume 4, page 359, 3599.
3059?
3599, volume 4. Dr. Ambedkar's response.
Instead of reading it, just tell us if you can just make the point.
The point simply is, so Dr. Ambedkar said
in the Constituent Assembly.
In the Constituent Assembly. Dr. Ambedkar said that, look, we have brought about an ordinance with effect from the 19th of July 1948, which would put in place a permit system. Your lordships would recall from the arguments prior that those who had left India and gone across the border, they needed a permit to come back for resettlement. That resettlement date, after the 19th of July 1948, they needed this permission. And that permission was very difficult to get. This, however, applied largely to the western border. On the eastern border, there is Mr. Iyengar, who at page 3672 makes it very clear to the Constituent Assembly that the permit system was not to apply on the eastern border. And for good reasons. That there was a substantial number of Hindus who still remained in what was erstwhile East Pakistan, who may have wanted to come over, who had not yet come over, and it was a continuing process. Among the Hindus who later came over was the first Law Minister of Pakistan, Jogendranath Mandal. Mr. Mandal, my lords, died in poverty, but he had several crucial interventions, and the most important was that he got Dr. Ambedkar elected to the Constituent Assembly from Bengal. And once that portion went over to East Pakistan, Dr. Ambedkar had to be re-elected from Bombay, and that's how he came on to head the drafting committee. So, my lords, there was a fluidity in identification of Indian citizenship. While on the western border, it was reasonably clearly drawn. On the eastern border, it was, as a matter of constitutional history and drafting, kept deliberately fluid. Well, lords, if I can now revert back to my note. The second submission, my lords, is that Indian citizenship is not ethno-nationalist. It's not based on language, religion, or culture. There is no superior or inferior citizenship based on ancestry of any type. This court should eschew any statement that may ever unintentionally be judgmental of such claims, especially in the emotive areas of India's northeast. For example, my lords, this very year, a seemingly innocuous statement in a tax case ended up in having consequences in Sikkim, my lords. The learned Solicitor General did appear there, and I just will pass on the order, my lords, for your lordships' consideration. Your lordships will see that it was a very, very Yeah, I'll just keep it. Probably just 1 minute. Take his hand over. Solicitor. If your lordship sees page 3. We think it just and proper and in the interest of justice to correct certain phrases in paragraphs 10A and 77 of the judgment by making the following correction. The sentence, therefore, there was no difference made out between the original inhabitants of Sikkim, namely the Bhutia Lechas, and the persons of foreign origin settled in Sikkim, like the Nepalis or persons of Indian origin who had settled down in Sikkim generations back, stands deleted. Lords, this was, people from Sikkim were entitled to a tax exemption. The question was, who all were citizens of Sikkim? Even an innocuous sentence saying that there was no difference, then, my lords, had huge emotive consequences. And, my lords, I say this with some experience, particularly when I went to Shaheen Bagh, was that people resent greatly when their Indianness is questioned. We are all Indians. And to borrow an Americanism, we may have come on different boats, but we are in the same ship.
July 1948 actually is
Please.
the date of the introduction of the permit system.
Yes.
I was actually just looking at 3599.
Yes, my lords.
Just let's actually read it because nobody had read it to us.
Please, my lord.
Learned brothers will also have the benefit of that.
Please, my lords, if your lordship.
Just and then we'll be done. The other things you have orally told us. I've also gone
Please,
through
my
that.
lords.
3599.
3599.
This was not Constituent Assembly debate.
Volume
This was a debate in connection with what?
My lords, with regard to citizenship itself, if your lordship sees the earlier pages.
This part of the Constituent Assembly debate?
Yes.
Okay.
Please, my lords.
Just that part, I'll
Please,
show you. You can read that one
Yes.
middle of
Then I
page.
come.
This permits us. You need not read the whole para. Okay, all right. You can just about 10 lines down. This permit system was introduced from 19
This
July.
provision had to be introduced because the government of India, in dealing with persons who left for Pakistan and who subsequently returned from Pakistan to India allowed them to come and settle permanently under a system which is called the permit system. This permit system was introduced from the 19th of July 1948. Therefore, the provision contained in Article 5B deals with citizenship of persons who, after coming from Pakistan, went to Pakistan and returned to India. Provision is made that if a person has come on the basis of a permit issued to him for resettling or permanent return, he alone would be entitled to become a citizen on the date of commencement of the Constitution. I may say, sir, that it is not possible to cover every kind of case for a limited purpose, namely the purpose of conferring citizenship on the date of the commencement of the Constitution. If there is any category of persons who are left out by the provisions contained in this amendment, we have given power to Parliament subsequently to make provision for them. I suggest to the House that the amendments which I have proposed are sufficient for the purpose and for the moment, and I hope the House will be able to accept these amendments. So that, my lords, is why the date was chosen and the architecture put in, that in the beginning we have to decide who are our citizens, who will then be voters, who will then participate in the general elections. Lords, curiously, all this thing about permits, and if you went over to Pakistan, had also consequences on facts of each case. There was a gentleman who went to school in Bombay. Then thereafter, he went off to the US for further studies. He then had property in Bombay. His family had property. He wanted to hold on to it. He asserted that he was an Indian citizen. His family was in Karachi. He became a minister out there. And then when questions came about his citizenship, it was as late as November 58 that he withdrew his petition before this court to assert that he was an Indian citizen. The gentleman's name was Zulfikar Ali Khan Bhutto. And my lords, he chose a citizenship whose Supreme Court then probably did not do him justice. Be that as it may, it's an oddity. There were all kinds of people.
All right,
Please,
now,
man.
I think we'll conclude there because we have to finish.
Just 2 minutes, my lords. I've pointed out Mirajkar, my lords. And I would also urge your lordships, my lords, that any large-scale decision which may have an inadvertent consequence of statelessness.
That you have made your point.
Please, my lords.
Thank you, Mr. Hegde. Now, who's next now?
Please, my lords. I'm grateful.
Please, Mr. Yes, I'll be very, very brief because everything has been argued in extenso. Because I appear for Assam Gun Parishad. I have filed IA number 74061 in writ petition number 562 of 2012. And my IA is in volume 3, page 1634.
Mr. Das, IA number?
It's 74061
2020.
of 2023 in writ petition civil number 562 of 2012.
And
we've filed our one-page written submissions.
brief submission is at page 2.
2 and 3, volume 2C. I just have two broad submissions.
Yes.
One belows that we are signatories to the original Assam Accord. Two, I fully support the learned attorney and the learned solicitor. And Milods, I just wanted to point out one judgment which has not been cited on general versus specific, which is 2014 8 SCC 319. And I just wanted to lay emphasis on just two paras.
What is the name of the case?
The name of the case is Commercial Tax Officer Rajasthan versus Binani Cements Limited. And I just wanted to point out only two paras. Paras 36 and 47. Only to answer your lordship's query, why Assam, why not Bengal, etc. Para 36, my lords may kindly have. The maxim generalia specialibus non derogant is dealt with in volume 44.1 of the 4th edition of Halsbury's Laws in England at para 1300 as follows. The principle descends clearly from the decisions of the House of Lords in so and so and the Privy Council in Baker versus Edgar, and has been affirmed and put to effect on many occasions. If Parliament has considered all the circumstances of and made special provision for a particular case, the presumption is that a subsequent enactment of a purely general character would not have been intended to interfere with that provision, and therefore, if such an enactment, although inconsistent in substance, is capable of reasonable and sensible application without extending to the case in para 47.
So you are saying that 6A was a special provision
I'm
intended to deal with a specific situation.
I'm deeply
Got you.
deeply obliged.
Thank
I'm
you,
grateful.
Mr. Thank you, Mr. Kamal.
Great.
Who is next now? Mr. Siu Singh?
Yes. But I'll rather than give your lordship numbers, if my lords just say it takes, but in
no, we've got the number.
two,
It's 117074 of 2000, 117074 of 2019.
and 181511 of 2019. So my written submissions are in volume 2, page 119 to 172.
Volume?
Volume 2, page 119 to 172. And the one-page note is at page 4 of volume 2C. And there are just three main points which I'll very quickly go over. The first is the learned Attorney General in para 7 of the note. My lord may just note this: learned Attorney General in para 7 of the note, and the learned Solicitor General at pages at paras 1 to 6 of his written submissions in volume 2, page 3. Volume 2, page 3, paras 1 to 6. And the learned Attorney General, there was a note, para 7 of that. I have relied on Tilok Chand to say that delay in this case should not be a complete answer. This, your lordships, ought not to even enter into the so-called merits of the challenges, because this is not a case where there are petitioners who are merely seeking assertion of some right of their own. Here, the petitioners are seeking assertion of a right which would strip away other people of rights which have accrued to them over a 27 or 30-year period. Today it's 40 years, but in 2012, when they filed the petition, it was a 27-year period. And there are constitutional rights have accrued, which are the right to have rights. People have become citizens by naturalization, because 6A is a sort of species of naturalization. They have become citizens by birth, etc., and all that is sort of stripped away.
Have we got what is the next point now?
No, on this point, what is very important, and that this is where I come in. Tilok Chand, the argument was that they cited the judgment of the learned two-judge bench in Assam, Sanmilita, to say that Tilok Chand ought to be reconsidered. What the two-judge bench failed to notice was that Tilok Chand had been followed by another constitution bench in Rabindranath Bose, which your lordships will find in volume 5 at page 1255.
Volume 5, page 1.
Volume 5, page 1255, Rabindranath Bose.
1970, 1 SCC, 84.
It's in my one-page note notes in para 2.
You mentioned.
Now, what is important is that in Rabindranath Bose, an express plea was made that Tilokchand needs to be reviewed and was rejected by the Constitution bench. So, my lord, may just straight away come to page 1266 of volume 5. I'll just show two short passages.
Not necessary. We are making a note of it. Just tell us the paragraphs. That's all.
Para 31 at page 1266 of volume 5 and para 32 and 33. In para 32, there's an express plea.
At page?
Page 1266 to 1267 of volume 5.
Fair enough. So the plea for review has been also rejected by a CB.
By a CB
Yes,
and para 32 is that express plea for a review.
Fair enough. You made the point.
And the CB goes on the basis of accrued rights of others. Here the seniority rules were challenged. They said that people have now benefited from seniority, that they have moved on, and therefore Article 32. So there's a categorical the statement of law by the CB that where third-party rights have accrued, Article 32 will not be invoked and will not be entertained.
That if we accept the point which has been made on your side is that if we accept the submission of the petitioners, it will also result in statelessness because and the solicitor also pointed out that the joint communique of Sheikh Mujibur Rahman, the then Prime Minister of India, stated that Bangladesh assumed responsibility for those who entered India post 25/3/71.
71, yes. Now, so this is one part I submit was that it's not open.
Next point now.
And if at all they were right, that would have to be referred to a 7-judge bench. So that's not really open.
Next point.
Now the next point is, Millards, that one of the principal arguments really when they filed these petitions was that the Assam Accord has been picked, there's a picking and choosing, and only 6A has the part of Assam Accord which has been implemented is only that which was enacted in the form of 6A, and the rest of the Assam Accord has not been implemented, leading to supposed large-scale migration into India and what they call infiltration and so on and so forth in the state of Assam. Now, the petitioners themselves prevailed on the court while making a reference to your lordships in the 5-judge bench to continue to entertain the petition and to implement all the rest of the Assam Accord. And between 2014 and 2021, in fact, in large measure, all the other provisions have been implemented. All the border fencing, the searchlights, etc., the beefing up of security on the borders, and the supposed weeding out of the infiltrators.
Now, if you can go to your point number 4, Mr. Singh. There's something much more important which we wanted to explain from your note. This is okay that they've.
I just want to point out for the affidavits that this will come on affidavit. So my lord may just note that
now we are in
No, I only want to tell your lordship.
Interveners now. We have to get on with the rejoinder.
No, absolutely.
Now go to point number 4. Just explain that because that's a conceptual point nobody else has made.
Yes, Lord. Section 6A does not violate Article 14, but is rather a step forward to legalize the determination of foreigners as per the Assam Accord, signed with stakeholders who led the agitation, and definitely does not violate Article 14 rights of the petitioners. This section may be treated as a version of citizenship by naturalization under Section 6, read with the 3rd schedule. Now, let's
just read it and so that we'll be able to understand.
The only difference being that whereas Section 6 did not apply to countries in the 1st schedule, with the creation of Bangladesh in 1971, the said exclusion became meaningless as far as its citizens were concerned, and a special provision was needed to deal with them. And just as grant of citizenship to any person under Section 6 does not violate Article 14, grant of citizenship to a class of persons under Section 6A does not violate the right to equality as well. The point in citizenship by naturalization is based on continuous residence in a country. In our case, it was 7 years originally, then it was made into 11 years. So a person who is not an illegal and is residing in a country for a particular period can then ask for citizenship by naturalization. Under Section 6, read with the 3rd schedule, the 3rd schedule sets out the conditions. Section 6, it is granted to people. Now, 6A is a sort of species of that because it is again based on continuous residence here. But what happened was, because Pakistan in 1955, Pakistan had East and West Pakistan had a very special status by India. So the first schedule said that Section 6 said that naturalization will not apply to citizens of those nations named in the first schedule. That first schedule is now repealed. But it was, so basically, citizens of East and West Pakistan were not eligible to that particular route. Now in 1971, Bangladesh is now no longer part of Pakistan. It is a friendly nation. It has it has never had even one day of history of enmity or war or anything with India. It's no longer Pakistan. I mean, we have the reality is that once Bangladesh was formed in December 1971, it has been, in fact, we were the midwives who helped to give birth to that nation. And we have had friendly nations throughout. So now, conceptually, that exclusion really didn't, it was there in the statute book. Bangladesh was still a sort of a successor to.
That was their argument, actually.
But being in the statute book, but that bar really didn't apply. So what was done, but the political settlement in the Assam Accord, because there was massive agitation, etc., was that you have you create another section where there'll be a form of naturalization to recognize those displaced persons or refugees who have come from Bangladesh and who have lived for a long period of time in India. And therefore, that it is sort of, it's one species of that. So I'm only saying, just as 6 is never tested on 14, which person is granted citizenship by naturalization, another person can't say, why have you granted it to so-and-so under 14? Same way, I'm saying that conceptually, 6A should be tested on the same anvil. That merely because you're granting it to one class of people doesn't mean that there's a violation, certainly not any violation of petitioner's rights. Violation might be claimed by another class who are denied citizenship. And other people say, I'm identical to Mr. Singh, why am I not given citizenship when he's been given it? But can somebody else say, why are you giving it to him and not to others? A person who is not eligible for it. So this is just the slight thing. Now, the last thing, I'll only give your lordship the page numbers and I'll close that.
Yes.
The para 5, 6A did not encourage further infiltration, but rather created a fetter. The state's population growth post-1971 compared with the rest of the country does not support the argument that it encouraged infiltration. See Union of India's affidavit dated 5th December 2014 at paras 9 to 11 and para 14, volume 3, pages 1192 and 1195. Now, here your lordship will take 3 paras in particular, para 9, 11, and 14 of that affidavit. And 14 is very important because this entire alarm, I would like if your lordship could read para 14 at page 1195, volume 3, page 1195. The entire alarm arose in 2004, a year before the Sarbananda Sonowal judgment came, because of an answer in Rajya Sabha, and that answer in Rajya Sabha said that 1.2 crore people from Bangladesh are in India, of whom 50 lakhs are in Assam. That was an estimate given. That was corrected in Rajya Sabha, saying that there was a field survey done, and the field survey itself said this is only hearsay by interested parties. But that footnote saying that this is that we have not been able to verify this is only based on hearsay by interested parties, was not placed before Rajya Sabha. So a correction was made before Rajya Sabha. Please just see that for a moment. Volume 3, page 1195. This has been virtually the foundation of all this. The previous paras gave the charts in the same, I showed your lordship 1192, etc. Now 1195, it is respectfully submitted that the petitioner, this is the Union of India, 5th December 2014, that the petitioner and the writ petitioner had mentioned about the response to the Rajya Sabha Unstarred Question 332 dated 14 July 2004, wherein it was informed that there were 1.2 crore illegal immigrants, illegal Bangladeshi nationals living in different parts of the country. Out of them, 50 lakhs were in Assam. In this connection, it is clarified that a statement correcting the answer to the Rajya Sabha unstarred question was placed in the House, stating that the estimated number of illegal immigrants reported by the field organization had a clarificatory note which was inadvertently not seen. The clarificatory note made it clear that the reported figures were not based on any comprehensive or sample study, but were based on hearsay, and that too from interested parties. Therefore, no realistic figures can be given for illegal Bangladeshi migrants in Assam. In the case of West Bengal also, the figures are based on unreliable estimates and are incorrect. A copy of the statement correcting the answer to the Rajya Sabha unstarred question dated so-and-so is annexed herewith and marked as annexed to R1. Now, if your Lordship just moves 2 pages back to 1192, the actual figures, 1192 para 9,
Yes.
there's been a lot of alarmism, Lords, which is not rooted or grounded in reality. Now, see the actual figures at para 9, Lords, of the same affidavit.
Yes.
It is submitted. May I read that, Lords?
Yes.
It is submitted that as per records available, para 9 Lords at 1192, it is submitted that as per records available, about 52.31 lakh displaced persons from former East Pakistan had migrated to India between 1946 and 1971. Just these 2 paras, very short paras, at para 9 and 10, it is submitted that as per records available, about 52.31 lakh displaced persons from former East Pakistan had migrated to India between 1946 and 1971. Out of these, the displaced persons numbering 41.17 lakh who arrived up to 31st March 1958 were called old migrants, and those who arrived between 1164 and 25/3/71, numbering about 11.14 lakhs, were called new migrants. Out of the 41.17 lakhs old migrants, about 31.32 lakh were settled in West Bengal and 4.87 lakh persons in Assam. Out of the new migrants numbering 11.14 lakhs, 2.12 lakhs persons came to Assam. The remaining old and new migrants were rehabilitated in different states of the country under various schemes of the Government of India. Wide range of relief and rehabilitation measures were undertaken by the Government of India for rehabilitation of old and new migrants. The rehabilitation of old migrants was by and large completed by the end of 1960s, and that of new migrants in 1980s. It is submitted that the state of Assam also witnessed migration from other provinces of undivided India even before partition of the country due to economic reasons. And your Lordship will see this decadal variation between 1911 and 1951 or 1961. There's a huge amount, much higher than the national variation. The decadal growth in Assam, 1911, 1921, etc. Now, historically, this has been well recognized, and in my written submission, I've set this out, that even in the 19th century, leave alone the 20th century, there was a lot of Bengali settlements in Assam, and it led to a lot of disquiet because at one time Bengali was made the official language for about 12 years in the 19th century. The British had made it the official language of Assam. That had led to huge resentment. So every time Bengalis settled in Assam, I'm not, this has nothing to do with Pakistan or India. This is way before independence. There was always resentment. There was always an upsurge of this fervor, and rightly so.
We'll wrap
So
up.
I'm only pointing out this has to be kept in mind. This alarmism has a historical background to it, which must be kept in mind, because ultimately, human beings in large numbers get affected by an alarm against a race, not people from Pakistan, but a race of people who happen to be settled over there over the last 150, 200 years. Deeply obliged.
Thank you, Mr. Singh.
Only one.
Mr. Trivedi, you are for the AASU.
Well, para 9 may be seen with para 40.
Para
That's all.
14.
Of course, numbers, my lord, may not decide the validity, but
Let's see that.
Nine
Now,
will be
14
read.
also he read out 49.
What is the Rajya Sabha? Yes.
That Rajya Sabha clarification. That it was based on hearsay, the
The
clarification.
learned solicitors, para 1 to 6 are very clear in your submission.
She is appearing for Ms. Malvika Trivedi.
My lord, I,
ASU in writ petition civil 562 of 2002.
my lord, respondent number 6 in writ petition 562 of 2012 and respondent number 5 in writ petition 876 of 2014. My lord, my one-pager written submissions are in volume 2C, pages 7 to 8, PDF 910.
Page number?
PDF page 910, my lord.
Volume 2C. No?
Pages 7, 8. My lord, just to give a brief background on All Assam Students Union, because a question had come from the Honorable Court that why Assam and why not West Bengal? The answer lies herein. It is because of this long agitation from 1979 to 1985, my
Would you like
lords.
to read that note? I will.
Please, my
So
lord.
that let's see how
That's
you
the
focus.
first part of my note, and
Certainly.
also because.
Let's read that. It's important
Yes,
actually.
yes.
Let's read it.
So, my lords, the first point, the backdrop of the Assam Accord dated 15th August 1985. The Assam Accord was signed between the Union of India, State of Assam, All Assam Students Union, and All Assam Jan Sangram Parishad in the backdrop of a 6-year-long movement, 1979 to 1985, in the state, against the unabated illegal migration of foreigners into Assam, their settlement in Assam, and their inclusion in the voters' list. During the agitation, about 860 persons who are considered as martyrs during the Assam movement lost their lives and thousands were injured due to police action. Very recently, the Martyrs' Day was actually in commemoration of these people who had lost their lives was held, my lords, in Assam. The state suffered tremendous political uncertainty with 4 changes of government and 3 spells of president's rule during the 6-year period. And this is very important, my lords, clause 13 and 14 of the Assam Accord, because this is on restoration of normalcy, which is the underlying concept under section 6A. That is the purpose it was brought into, for the purposes of restoration of peace and normalcy in the state of Assam. And a book that sums it up, The Quest for Modern Assam by Arup Jyoti Saikia, which is also a part of the compilation. It has 2 chapters on each and every meeting that had gone on that time with the government and with the All Assam Students Union. The run-up till 1983, thereafter in 1985, after the Prime Minister's assassination, then in 1985, what were the events which led to the agreement behind this Assam Accord, and then it came into play. And the background that was discovered was also discussed and when finally agreed upon were the 1964 riots which had happened in East Pakistan, where there was mass massacre of the population, and therefore they had escaped into India. So therefore they became a part of the 1967 electoral rolls. So therefore that part of the population that had come in at that stage was included, but the part after that, then the government agreed would be kept disenfranchised. Therefore, the period till 1971 where they were not included in the electoral rolls. So therefore, in the history of this entire accord is the agitation and therefore the difference between West Bengal and Assam for the purposes of this particular section. Now coming to my second point, where a lot of arguments were raised by the petitioners on the infiltration continuing. For that, I just want to point out one para from the reference order itself. Para 46 is very important because the point that we are making here is that the constitutional vires of a statutory provision cannot be tested on the basis of faulty or inadequate implementation of the said provision. And if my lords will only have para 46 of the reference order, it says, if I may just read the introduction, on an overall consideration of the immediate dimensions of the issues and the potential that the same have for the future, we issue the following directions under Article 142 of the Constitution of India. One is border fencing, border roads, and provision for floodlights. The second is foreigners' tribunals. The third is existing mechanism of deportation of declared illegal migrants. And in that, 48.1 preparatory work such as selection of vendor system, development by system integrator, appointment of staff and training, etc., has already been directed to be completed by the end of January 2015 by order dated 27/11/2014 of the court. 48.2, the remaining work of updating the NRC will now conform to the following time schedule, which will be strictly adhered to. And 49, all the cases, so on and so forth. So therefore, if my lords will see that this is the implementation that had to be carried out as per the Assam Accord, the absence of this implementation cannot be a reason to fault Section 6A. Then coming to the third point, which has already been addressed, so I will only talk about the case law very briefly to say that the petitioners are also disentitled from claiming the relief on account of inordinate delay. And for that, I only want to point out that whether it is Ram Chandra Shankar Deodhar, whether it is Rabindranath Bose, or whether it is Trilok Chand, the underlying concept in all these judgments is that if the rights of another set of people have already got created, then the delay in filing the petition cannot be then waived off. And my lords will just see, I have just given a few instances when they could have challenged and they did not. And therefore, these rights have now crystallized over 40 years. One instance that I've given, the report by the Lieutenant General S.K. Sinha was prepared on 8/11/98, which in detail talked about this problem.
Then comes that reply to the unstarred question,
Yes,
14
yes.
July 2004.
Absolutely. Absolutely.
And the writ petition Sarbanand Sonowal, you say, was filed in 2000.
Absolutely. And this actually considers the Assam Accord in para 18 and in para 33 in great detail. The next point, I will just on the legislative competence, I just want to point out one article just for the purposes of saying that how 5, 6, and 7, articles 5, 6, and 7, the purpose was that they would work themselves out at the commencement of the Constitution. I only want to point out Article 394. If I may read, this article and Articles 5, 6, 7, 8, 9, 60, 324, 366, 367 shall come into force at once, and the remaining provisions of this Constitution shall come into force on the 26th day of January 1950, which day is referred to in this Constitution as the commencement of this Constitution. So therefore, my lords, the 5, 6, 7 sections, the articles were supposed to come into effect on 26 November 1949, and therefore at the commencement of the Constitution, therefore by 26 January 1950, they were supposed to come into play for the grant of citizenship. And thereafter, therefore we have said that the purpose of Article 11 was only to add, not to deprive anybody, but to add a certain class of persons which were not covered by Articles 5 to 9. That is the point that I've covered in point 4. I've also given detailed submissions, my lords, which is there already on record. Another judgment that I wanted to add, because Izhar Ahmad, when it discusses in great detail Article 11, it is a Constitution Bench judgment. It is very clear on what Article 11 entails, and it has been followed in state of UP versus Shah Mohammad. I have given the volume number and the pages, and also the para 5 of state of UP versus Shah Mohammad. It's a case very similar to Izhar Ahmad, and it follows Izhar Ahmad, and again reiterates that Article 11 is supposed to then come into play for the purposes of the laws to be made for citizenship. My fifth point, very briefly, I have tried to state that Section 6A is not the only statutory provision to be based on a political agreement. And I have given two instances for this. Article 371A, which is the 13th Amendment Act, and it is based on the agreement between the Government of India and the leaders of the Naga People's Convention. Then I've also cited 6th Schedule, which is which is based on the memorandum of settlement entered into between the Government of India, Government of Assam, and Bodo Liberation Tigers. And this is now on the autonomous districts and autonomous regions. It covers the areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Then I have just added some case law to say that the classification on the basis of historical or geographical reasons is absolutely valid. And therefore, I have only added the judgment in state of MP versus Bhopal Sugar was already cited before my lords. I have only added one more judgment on geographical classification, which is Ram Krishna Dalmia versus Justice S.R. Tendolkar. And I have also added Clarence Pai versus Union of India. And in the end, I'm only making a point that if the history of this agitation is seen, it is actually wonderfully spelled out in the Quest for Modern Assam, which is also a part of volume 4A by Arup Jyoti Sakhya. It'll be very clear that what had happened throughout this process and why, because of the Bihar settlers, why, because of the Bengali language, and why this agitation became much more than what the people of Assam could handle. And therefore, for peace and normalcy, the Section 6A was brought about.
Thank you so much. Thank you, Mr. Reddy.
Please, Your Lordship. Well, I'll make a very quick fire 5 points. So your Lordships will not have to be.
You are in IA, what, 24
Well,
of
the IA,
2017?
the IA that Malaj is 24 of 2017.
Assam State Jamiyat Ulema.
That's right, the State Jamiyat. Malaj, we've been deeply involved in all the CAA matters, etc., and we've been involved in the Assam Accord settlement right from the beginning. Malaj, we have I will not repeat anything that my learned colleagues have said.
Where is your note, Mr. One?
Mullah, your Lordship will find the note in volume 2C at
2C.
pages 5 to 6. PDF page 7.
Yes.
And Mullah, the earlier note that I had given, your Lordship will find in volume 2. There's the details are all given there. This is very, very brief because your Lordships want to just see.
Let's have a look at your note, Mr. Sashi.
So if your Lordship will see at PDF page 7, volume 2C, well, it's the first point. If your Lordship will focus on that, the first point essentially is to disclose that the migration issue is a global issue, and for Assam it continued over centuries. So it wasn't as though something had suddenly happened, and the amalgam of different communities moving into migration, bringing different communities into Assam gave what sociologists have said is a salad bowl. So there's two perceptions about a salad bowl and about a mosaic, or on the other hand, it would be a melting pot. So the preferred view seems to be of a salad bowl. This is how it existed. But of course, as your lordships have heard from the others, there were issues that were different as far as the western border was concerned and the eastern border. The issues on the eastern border was the constant move from one part of Bengal to another part of Bengal. So Assam was in a sense separate because they didn't want to impact on the issues between the two parts of Bengal. Assam then therefore becomes in a sense collateral to that issue. So Assam issue was never resolved in terms of the permit system that was introduced in the West. And the permit system, your lordships might recall, was particularly focused on the issue that people who had left and their homes had been given to refugees coming in from western part or from West Pakistan could not then be asked to evacuate their homes that they were given as refugees to return to people who had come back. And therefore, the permit system was particularly carefully monitored. This didn't happen in the eastern part, and particularly as your lordship saw Justice Baharul Islam's judgment, his speech in the Rajya Sabha, we've mentioned all that here, my lords, and therefore a separate issue had to be framed as far as the eastern side was concerned. And that, of course, the 64 was obviously a landmark point, 64. 66 follows because 64 follows with the 67 electoral rolls. But the critical matter, my lords, is the 1971. 1971, if your lordship will see here in point number 2, if your lordship will see, Bangladesh had already introduced their citizenship law in 1972. We were introducing in 1985. So in effect, the 1971 aligns itself with the Bangladesh law. So there is no gap between Indian citizenship and Bangladesh citizenship. Your lordships were asking if it had something to do with Operation Searchlight and the migrations that would have been caused due to distress because of the Pakistani army operating. The Bangladesh government said they would take back all the people who had moved during that period. Because if they were in Bangladesh on the first day, which was on 25th of March, they would be citizens under the 72 law. And therefore, we were only concerned with people who were not in Bangladesh on the 25th of March. Those citizens would be taken care of, or those people would be taken care of by the Indian law. And it aligns. Now, my lords, if for any reason the 71 alignment is changed for any reason, it would mean that 40 years later, there are a huge number of stateless citizens, something to which we are not yet signed as far as the convention is concerned. But Government of India has always been careful about not creating or not being seen in the world as creating stateless citizens. And that is very critical point why your lordships would wish to uphold the 71 as the so-called cutoff date, though there is some issue about whether it should be called a cutoff date at all. So, my lords, that's point number 2 in my submissions. And my lords, point number 3 only follows upon what arguments have already been made, that it didn't freeze, the issue of citizenship didn't freeze in 1948 under the Citizenship Act of 1955. It continued with 6A, and then it continued subsequently in 2019 when further amendments were made for citizenship. Those may well be under challenge, but at least in theory, it was possible for the citizenship to continue in terms of fresh legislation. Then, my lords, the last 2 important points are, now there is a fresh affidavit that's been filed by Government of India. Those 2 points, the last 2 points, 4 and 5, indicate that the alarming picture that somehow emerged is not, my learned friends just before me had indicated this, but that alarming picture was misplaced. That the number of people so-called coming in was completely misplaced. Firstly, because the migration figures, as we now see from the affidavit, are much less compared to the ones that have been projected earlier. And then, my lords, in view of this affidavit, I would urge your lordships to consider whether the monitoring bench is the appropriate bench to continue with any issues that are indicated for future, and many of those issues are mentioned in the affidavit, rather than this honorable bench having to worry about what to do about the future prospects.
Thank you, Mr.
So, my lords, the only issue to recall is whether we are a salad bowl or we are a melting pot. Well, that's very critical in terms of sociology to understand. Your lordships have already been told about how the cultural issue was protected by the schedules by which the culture and autonomy of the tribes of Assam was protected. And they are the ones who should really have been concerned, not the others. This is my submission. Deeply obliged, my lords.
Yes, Mr. Sirma.
I won't take more than 2 minutes, Miller.
Yes.
My application, Miller, IA 26869, Miller. That's on page number 1616 in volume 3.
Year number 268.
26869
Nine.
at page 1616 of volume 3. Page 1616 of volume 3. And my small short note, Miller, in volume 2C, page 9. My lords, all the points, my lord, raised by me, formulated by me, my lord, are adequately addressed now. So I don't want to waste the time, my lord, only to say one thing. That is, with a particular reference to argument submission made by Ms. Indira J.C. Senior, my lord, that aspect regarding 29 mil, that I fully adopt, my lord, because otherwise I would have argued that.
Thank you, Mr. Sirma. Mr. Farad, sir.
I am appearing. Your lordships will have page 11 of the volume 2C. I'll only rely on the one page, my lords. Although I've submitted a detailed written submission. Page 11 of that is my submission. 3 short points for your lordship's consideration.
Volume 2C, page.
Page 11 is a one page, my lords. I appear for my lords in IA 10 in WPC 562 for Social Justice Forum, my lords, which is an organization that works for a composite culture in Assam. Well, the first submission for lordship's consideration is that the right to culture which they have asserted under Article 29, that in my respectful submission can never extend to denying somebody's citizenship. The reason for that is, the citizenship regime under Article 14, Article 14 is the only article your lordships will normally test any citizenship regime under. That is a regime of civic nationalism, a non-discriminatory basis of grant of citizenship. The minute, my lords, we elevate culture to the extent of denying somebody else citizenship, effectively we have transgressed from the area of civic nationalism to cultural nationalism. Plus 29 certainly cannot extend to denying somebody else citizenship because the nature of citizenship regime itself under the constitution then changes. Well, that's my first respectful submission. Your lordships will have Article 29 just for a moment. The language there is, have a distinct language, script or culture of its own and shall have the right to conserve. Well, 29 is premised on a multicultural society. It is premised on multiple cultures and you have a right to conserve within that multicultural space your own culture. It is not a right for cultural exclusivity. Well, that's my respectful submission to your court. The way they have framed it, that I have a right to cultural exclusivity under 29 to deny other citizenship. The language, the plain text of 29 does not permit that. In fact, I would go so far as to say that if their arguments are accepted, Article 29 will in effect cease to exist. Because 29 is premised on a multicultural society. And in that respect, your lordships will have Article 51A of the Constitution, subclause F. That talks about fundamental duties. Because Article 51 capital A subclause F is fundamental duties and it talks of composite culture. Every citizen's duty to maintain composite culture. Plus composite culture is a mix, is a bouquet of all the cultures within India. Therefore, when we read the constitution as a whole, Article 29 can never extend to denying somebody else citizenship. Now, just one example in that respect. For instance, in Malaysia, we have Bhumiputras. Literally it translates into son of the soil. Malaysia was very similar in facts to this situation. Due to British policy, Chinese and Indian migrants were moved into Malaysia. The indigenous Malays, as they were, had a problem, had angst against this movement. Now, citizenship is there for everybody across the board. Chinese Malaysians, Indian Malaysians or Malay Malaysians. But there is affirmative action which is provided because the Malays were socio-economically backward. So maybe there are aspects which, if they were to show that they are socio-economically backward, my submission is nothing on the data to indicate that, then those things can be taken care of. But you can't pitch it so high as to citizenship and then say nobody else will have citizenship. That's on point one. My second submission is that insofar as the reliance in Article 325 and 326 is concerned, plus 325 on its own terms, I'm not going to take your lordships to it, but on its own terms has the same markers of non-discrimination as in Article 15, race, religion, caste, etc. So 325 in fact goes against them because the citizenship regime has to be based without discrimination on basis of religion, etc. So many arguments, even on the grounds of change in demographics on religion was made. 325 prohibits that kind of discrimination, number one. Plus number two, under 326, the electorate is defined. It is by adult suffrage. At intervals, it has to be brought, the electoral list is changed. Plus that by itself envisages a continuously changing electorate. The composition of the electorate under 326 does not give a right to any specific group to have electoral dominance. Well, that's my submission for your lordship's consideration. 326 does not envisage that any specific group will continue to have electoral dominance. In fact, the terms of 326 are indicative that there is a flux in society, things can keep on changing, and therefore electoral roles must keep on changing. Well, that's the second submission. Well, my third and final submission for your lordship's consideration is that Assam Accord was, one aspect of the Assam Accord has been legalized in the form of 6A. There was another aspect, which was that a whole lot of violence occurred. And that was, amnesty was granted for that under the Assam Accord. For instance, in 83, there was a serious massacre called the Nelly massacre. Although, for serious crimes, the text of Assam Accord says that that is in effect excluded, but the way it operated on the ground, that all of that, in effect, was effectively, amnesty was provided. So today, after so many years, to pick on one aspect of 6A, whereas the petitioners represent groups which benefited from non-prosecution of multiple cases, in Nelly, there were deaths of 1,500 to 2,000 Bengali migrants. So all of that was shut out. So it's a compact to pick out one now, and you have benefited from other aspects of the compact. In my respectful submission, your lordships will look at that very closely. That's my respectful submission. I'm extremely grateful to the court.
Thank you, Mr.
Lordship, my written submission in volume 2C at page number 9. In IA number 190221, I will take only 1 minute. Many foreigners illegally settled in the Assam and also other parts of country. It affects not only national security, but also democratic setup in the Assam and other states like Bengal also. Section 6A confers citizenship to large number of persons without being actually born within the territories of India. Section 6A seeks to provide protective discrimination to the class of illegal immigrants. Fourth point is, there may be some lacunae and drawbacks in the provision of the Section 6A of the Citizenship Act 1955 as read by the petitioner. But the
6A is unconstitutional. You are saying 6A is unconstitutional or constitutional?
Sir, it is constitutional. I am saying only that. And there may be some lacunae and the drawbacks in provision of the Section 6A of the Citizenship Act as read by the petitioner, but the intention of the lawmakers is certainly fair. The provision of Section 6A are in favor of the integrity and national security of India, but there should be practical approach because immigrants may be illiterate and they cannot be at the ventilator for indefinite time. My humble submission.
Thank you, Mr.
My humble submission is that the provision of Section 6A of the Citizenship Act 1955 should be declared valid and the constitution.
All right, we've seen it, yes. Now, who else? Who else?
I'll just take exactly 2 minutes.
Yes, which?
And I appear for my lords Assamar Pragya Jyotish Priya Khilanjia Musalman Union Parishad, APKM.
Some submission, one-page submission.
Not one page, it's not,
Have you
I will
put some, have you filed some submissions?
yes, Your Lordships.
Oh, so what is the point? Who are you appearing for?
I'm appearing for, in IA number, Your Lordships, in 562, 41036 of 217, and in WPC 274, my IA number is 153061 of 2022. I will not bother Your Lordships with all the details because everybody else has argued. I will.
Anything special now?
Yes,
I think.
Manoj.
What is that?
Otherwise, I will not bother. Let's to decide the questions before my lords in question number 4, 9, 10, and 11. There is a question of a friendly country, and Your Lordship has been kind enough to take affidavit of the union. I am only submitting for Your Lordship's consideration that if Your Lordships can also ask the union to file an affidavit qua their interactions with this friendly nation on point number 4, 9, 10, and 11.
All right, we'll get
That's
to
one.
now. Yes.
2, my lords, 6A, absolutely technically, is a restrictive in nature provision, which restricts the rights or the provisions which are available in 6 before 1985. So it's not actually giving out something, it's restricting something for the provisions of section 6. 2004 amendments came later on. That's the second aspect. And third aspect, to confine myself to 3 minutes barrier, is that culture, point number 3, the abrogation of culture and dilution of culture, Your Lordships, will have to be considered on the parameter of the numbers. If more number of people, as it happened here, a lot of Bengali origin people adopted Assamese language, and therefore Assam language today is Assamese. So it is expansive in nature again. A lot of
That
Bengali
point is
origin.
made now.
Yes.
Thank you.
Thank you. Be brief.
But I appear in specially petition number
What's the point?
214.
What's the point?
Malad, the point is, I will only confine to 2 aspects.
You're for the
One is-
intervener.
No,
Sorry.
Malad, I'm in for the petitioner in Akhtara Khatun, 501.3 and 501.6. Malad, I have uploaded my written submission just now, that's 1 pager only. And I confine myself only on 2-3 aspects. Malad, one is
What
that
does the SLP arise from?
this is against the order of the High Court, whereby the individuals were declared as a non-citizen.
High Court declared
Yeah.
individuals as non-citizens.
And that is against that the SLP was filed. That was an individual case, but it has been tagged along, and this item number is 501.3 and 501.6.
We will
We went
just
again.
detag. We will detag your case.
Only Malad,
No, we'll detag this
Got
case
it.
because we don't know what the, let the bench
that is
deal with this.
the
Why should we
tribunal
tag to the
has,
constitution?
the tribunal has declared as non-citizen. Then we went to High Court. Against the High Court, we came to Supreme Court, and it has been tagged along with this batch of petition. Malad, I will make only 2 submissions. In 1 minute, I will finish. Malad,
There are 6 SLPs apparently. 1 second, just for clarity.
yeah.
There are 6 SLPs. I don't think we should be going into the facts of SLPs over here. We'll just detag those matters.
I'm only on the broad.
Let the, you see, there's some injustice may be caused to your client because, we are hearing a question of law here.
Yes,
We are in, there's a constitutional challenge which we are considering.
correct.
Individual facts of these 6 SLPs, after we deliver judgment, let it be placed before the
This
regular
will
bench.
directly affect the interest of my client. I will only make legal submission, not go into
Why?
the
But
fact.
you have not been protected under 6A also. You have been held to be a foreigner.
Yes,
So you will have to argue your SLP on facts.
that is true, my lord. The SLP has to be argued on fact. I'm not arguing on fact, and I cannot argue before
Right.
lordship because it is
All right.
confined only to
What is
6
it? Just in one,
The
one
point is that,
sentence.
my lord, Article 5 to Article 9 deals with specific, there is time and situation is specific, my lord. And Parliament has given under 246 read with
That point has been made
17.
now. That point has been made now.
Yeah, so therefore,
Article 10 and 11 both gives enough power, and
That point has been
the
made by
Article
repeated-
5 to 8, 5 to 9 were enacted
Thank you,
for the
thank you.
purpose and
As-
keeping in
thank you.
view
SLPs could
of the movement.
detach kar do, and after the bench, after that work, we'll place the because we shouldn't get it because we'll have.
So, good.
Yes, Mr. Diwan.
Yeah.
Before Mr. Diwan commences, we had asked for an affidavit by the Union of India. Learned solicitor was there. Can we just quickly look at the affidavit? Because then that way you can deal with the affidavit in the.
Everything that has been stated,
Actually, the affidavit of. Of India dated 11 December 23.
तुषार मेहता सर
Data आ गया ना कि how many people have been granted citizenship? Says it is only submitted. Assuming that the workload. Yeah.
May I read so that?
Yes.
I'm sorry, my lord, I was called somewhere.
No,
Your lordships are on page, my lord. I may not reread, my lord. That's the only reason.
that is which page are we on generally? From which? Words perhaps we can see, I think.
Yes, my lord. My apologies, my lord. I was not here. My lord, your lordship's query, what this issue is concerned, my lord, was how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners Tribunal Order 1964 with reference to the above period, that is 66 to 71. It is humbly submitted that the number is 32,381 till, Lord, this date, my lord. There may be few cases, my lord, which may be pending, my lord, somewhere in the High Court or before this Honorable Court. But broadly, this number would not vary. Para 6 is the second query of my lords. The estimated inflow of illegal migrants into India, including but not confined to the state of Assam. Lord, in substance, we have said that there is a porous border. They come clandestinely, and therefore it is not possible to give exact figure. It may not be an accurate figure, but the situation is a grim situation, my lord. I will not dispute the petitioners on that. Lord, para 7, your lordship's query was in respect of persons who are alleged to have entered India, including state of Assam, after 25th of March. It is, my lord, what is, my lord, the Foreigners Tribunal's status? Well, there are 100 foreigners tribunals. The total number of cases disposed of are 3,34,966. The number of cases pending are 97,714. And, my lord, against this tribunal's order, there is a writ remedy before the High Court. And, my lord, 8,461 cases are pending. Then, my lord, the steps taken by the union government at the administrative level to deal with illegal immigration into territory of India, including the northeastern states, particularly the state of Assam. My lord, fencing part I'll come a little later, but other, my lord, in last 5 years, Ministry of Home Affairs, Government of India has released a total amount of rupees 122 crores as monetary allocation for the functioning of foreigners tribunals towards the expenditure incurred to be incurred by the state. Then B, monitoring of deportation of detected foreigners and convicted foreigners in the state of Assam is done by a standing committee headed by a joint secretary to the Government of India in the Ministry of External Affairs and having member from the state government of Assam. The standing committee has held 6 meetings so far in this regard. The state government or UT administration have been requested to take various actions with regard to illegal immigrants. Periodic meetings are convened at the level of Chief Secretary and DGPs to review the enforcement of legal provisions related to illegal migrants. Police authorities in the state or union territories and other law enforcement agencies may be constantly sensitized on the issue of illegal immigration of foreign nationals and be appraised of the legal provisions. Police authorities and other law enforcement agencies may be advised to keep a strict vigil and take appropriate, are advised, not maybe advised, are advised, prompt action to detect, identify, and intercept illegal immigrants settled in state or UT concern. Adequate powers are vested with state governments or UT administration for detection, detention, and deportation of illegally staying foreign nationals. Suitable penal action are taken, there is a typo throughout, against illegally staying foreign nationals. After completion of legal proceedings, the movement of such illegal migrants may be restricted in detention or holding centers by issuing of appropriate orders under Section 3(2)(e) of the Foreigners Act, read with Para 11 of the Foreigners Order 1948. Action may also be taken against those who abet under Section 14(c) of the Foreigners Act. It's taken from the directive. Therefore, my lord, it is wrong expression. My lord, my apologies. Are directed, my lord, not may. Further, biographic and biometric particulars of such illegally staying foreign nationals are being taken. Immediate necessary action to cancel fraudulently obtained Indian identity document. It is further submitted that steps have been taken by government of Assam to stop or prevent illegal immigration in Assam. It is submitted that various means and mechanisms are used to prevent and stop illegal immigration in Assam, as well as detection and deportation of illegal foreigners from Assam. Now, second line of defense. Assam Police border personnel, along with Assam Police armed branch personnel, are deployed in the second line of defense behind the border outposts of the border guarding force, that is BSF, along the Anglo-Bangladesh border to keep vigil and to trace out infiltrators who might sneak past the BSF border outpost. The second line of defense is established as per decision taken in a tripartite talks held in March 99 in New Delhi. Presently, 14 number of border outposts and 14 numbers of patrol posts are functional as second line of defense unit in 4 districts of Assam, sharing international border with Bangladesh, to detect illegal migrants, carry out patrolling.
Just
and
1 second, sir.
Yes. Further, third unnumbered page 7. Further, additional 12 border outposts were approved at the second meeting of state level standing committee to monitor border security held on 24/12/2019 with a government memo dated 30th December 2019. These two second line of defense units play a crucial role in prevention of infiltration and detection of illegal foreigners. It is noteworthy to mention here that the second line of defense, that is border outpost or police patrols, is manned by both unarmed and armed branch personnel headed by mostly ex-servicemen, sub-inspectors who have adequate knowledge of border management, security due to their past military experience and can easily coordinate and communicate with BSF to carry out the joint or individual patrolling. It is submitted that the border outpost or patrol post personnel are not engaged in any other duties. Then every district in Assam has a separate border branch under the command of the District Superintendent of Police border. Further, additional SP border, Deputy SP border are specifically posted in districts to look after the border works under command, control, guidance and supervision of Superintendent of Police. Further, in every police station, outpost, watch post, as well as foreigners tribunal, border personnel are posted for border works Furthermore, 500 task forces are also formed as per the order of the Honorable Supreme Court to apprehend the declared foreigners. Because even after declaration, they escape so that they may not be deported. Further, the Assam Police Border Organization takes necessary steps to detect and deport the illegal migrants from Assam as per law. Generally, based on information collected during village survey, source information, public complaint, and intensive revision of electoral rolls, etc., regular foreign tribunal or doubtful voter cases are initiated under Section 14 of the Foreigners Act against a suspected foreigner if he or she is not able to produce any valid document in support of his or her claim of being an Indian national. Thereafter, the cases are referred to the concerned Foreigners Tribunal for opinion. On receipt of Foreigner Tribunal's opinion, the declared foreigners are apprehended and detained in transit camp for onward deportation to their country of origin, that is Bangladesh. Then watch posts. Watch posts are established in infiltration-prone areas of Assam to conduct survey to detect infiltrators and subsequent legal action against them. Case initiation. Presently, 159 watch posts are functioning in 23 districts. Border protection grid. For effective border management involvement of various stakeholders, central and state agencies is inevitable. For this, the Ministry of Home Affairs of India, with a notification dated 2nd January 18, had directed establishment of border protection grid along the Indo-Bangladesh international border with the involvement of the state authorities and other stakeholders. Government of Assam has since finalized the SOP of border protection grid for Indo-Bangladesh international border of Assam. Main objective of the border protection grid are as follows: to present a foolproof mechanism with a view to make Assam free from illegal immigrants by detecting and deporting them to their country of origin, and to present such infiltration, to prevent such infiltrations in future. To prevent cross-border crimes into Indo-Bangladesh border, the functions and responsibilities of different stakeholders are clearly mentioned. Then lead intelligence agency meetings, that are frequently held. I may skip that. 9 is relevant, with reference to the query, the extent of border fencing which has been carried out, the steps which the union government intends to take to complete the exercise of border fencing, and estimated timelines to complete the exercise of border fencing. India shares 4,096.7 kilometers of international border with Bangladesh. It passes through the state of West Bengal, Meghalaya, Mizoram, Tripura, and Assam. The border is porous, crisscrossed by rivers, hilly and mountainous terrains. Out of 4,096.7 kilometer Indo-Bangladesh border length, feasible length for fence is about 3,922 kilometers, and non-feasible length is about 174.5 kilometers. When there is a mountainous terrain or river, there is no fencing possible. To secure the Indo-Bangladesh border, Government of India has taken multi-pronged step to complete the remaining length either by fence or by technological solutions. For the entire Indo-Bangladesh border, about 81.5% fence work has been completed in feasible length, and work is going on in those feasible stretches where encumbrance-free site is available. Further, about 28.2% of non-feasible gaps, that is riverline, nala gaps, etc., in Assam and Tripura have been covered by deploying technological solutions. In remaining parts, in West Bengal, Meghalaya, and Mizoram, suitable technological solutions are being explored in consultation with Defense Research Development Organization and Central Public Works Department. In addition to above, keeping in view the vulnerability of the border, BSF had carried out a vulnerable mapping exercise to identify the vulnerable stretches, non-feasible stretches, or stretches along existing fence along the Indo-Bangladesh border. To cover these vulnerable stretches, Government of India has sanctioned a low-cost technological solutions covering a total length of 281 kilometers along Indo-Bangladesh border, which is in progress and likely to be completed by September 2024. Further, the Government of India reviews the progress of fencing work regularly through institutionalized mechanisms like Empowered Committee on Border Infrastructure being headed by the Cabinet Secretary, high-level empowered committee being headed by the Union Home Secretary, steering committee being headed by the Secretary Border Management, state-level standing committee being headed by the Chief Secretary of concerned states. Apart from this, to expedite the border fence work, it is being reviewed in Ministry at Joint Secretary, Border Management 1 level and Director level monthly and weekly respectively. All efforts are being made to secure the remaining length of Indo-Bangladesh border either by fence or by technological solutions. The fence work is likely to be completed in 3 years' time after availability of encumbrance-free site. The site is to be provided by the state, Manoj, that's the problem. And the technological solutions are expected to be put in place in 2 years' time. Specifically, state of Assam shares approximately 263 kilometers of international border with Bangladesh, out of which 210 kilometers has been covered by fence and remaining non-feasible length has been covered by technological solutions. It is specifically submitted that challenges have also been faced in the state of West Bengal with regard to illegal immigration. It is submitted that the state of West Bengal shares about 2,216 kilometers border with Bangladesh. Out of 2216.7 kilometers of international border with Bangladesh, 78% border of feasible length is covered with fence. The details of remaining length of feasible or non-feasible stretches in the state of West Bengal is as under. My lord, I have given the figures, my lord. And A, the status of feasible length in West Bengal, it is submitted that a feasible length of 435 kilometers remains to be covered by the fence. It is submitted that out of the same, 286.35 kilometers is pending due to land acquisition by the state. Further, it may be noted that about 149.154 kilometers stretch, including bridges, culverts, gaps, low-lying public protest, etc., which was earlier considered to be non-feasible, has now been considered to be feasible for installation of physical barriers, including fencing, sentry post, high mast light, etc., as per BSF and CPWD recommendation. Estimates are being prepared to cover this stretch also. It is submitted that despite all efforts, the progress has been substantially hindered due to the pending land acquisition issues with the government of West Bengal. The state government has not adopted right to fair compensation and transparency in Land Acquisition and Rehabilitation Act 2013. As per this act, in cases of urgency, the appropriate government can take possession of any land needed for public purpose, and such land shall thereupon vest absolutely in the government, free from all encumbrances. It is submitted that West Bengal government follows a far slower, more complex, direct land purchase policy. This is, my lord, the main hindrance, even for national security projects such as border fencing. Due to the non-cooperation from the state government regarding resolving various issues of land acquisition, considerable delays have occurred in acquiring the necessary land, thereby impeding the timely completion of fencing in West Bengal along Indo-Bangladesh border, which is a vital national security project. My lord, I have avoided giving any correspondence, discussions, details, etc. With a view, my lord, not to make it other than, my lord, just fact specific. But this is the problem we are facing, and the central government, my lord, can do little in land acquisition. Then status of non-feasible land in West Bengal.
Mr. Solicitor, who pays the compensation, union or the state?
The state.
Oh,
But, my lord, if this is not the cause for which urgency clause is to be invoked, I don't think there can be any other cause. Integrity of the state, security of the country. Direct land purchase policy usually is adopted in case when you are acquiring land for some industrial purpose or industrial township, etc., not for national security concerns.
Issues of compensation mainly.
Correct. But, my lord, that has to be priority, my lord, even if no, I'm sorry, my lord, I'm sorry, my stand corrected. For border fencing, we pay the compensation.
Right.
Only, my lord, they are the agency which can do it under the Land Acquisition Act.
But they follow the direct purchase policy.
Direct purchase policy, my lord, which for border, they may follow, my lord, we have no difficulty, but for border fencing, they cannot follow. Then urgency clause will have to be invoked. And my lord, I'm sorry, I stand corrected. The Union of India pays the compensation. Then status of non-feasible length in West Bengal. It is submitted that the length of non-feasible stretch to be completed is 112.780 kilometers, which falls in Sundarbans areas and is being planned to be covered by deploying technological solutions. A joint physical inspection has been carried out by BSF and CPWD to explore the feasibility for construction of 9 number of outpost towers in Sundarban areas which can house surveillance equipments. It is further submitted that the ministry has also sanctioned 301.2.5 kilometer replacement upgradation of new design fence in West Bengal. Out of this, 56.21 kilometers new design fence work is in progress, and for remaining length, tendering is in process. It is submitted that to secure the Indo-Bangladesh border in West Bengal, Government of India has taken multi-pronged steps to complete the remaining length either by fence or by technological solutions. If the state of West Bengal cooperates in acquiring the land and handing over the land for fencing, the central government shall complete the process without any delay. Lord, this is, my lord, in respectful response to the order passed by your lordships, my lord, on the earlier occasion. My lord, before the petitioner starts, my lord, only one thing. I don't think, my lord, that may have any relevance for the purpose of deciding validity of Section 6A. But some history referred to by my learned senior friend, Lord, it seems he has read a wrong book of history. Assam was never a part of Myanmar. Lord, that because this has some relevance when we deal with some other matter at some other level, in some other, my lord, composition. It was never a part, my lord, because Myanmar has now, my lord, maximum immigration. And therefore, to say that it was always a part of Assam.
India of today what is Assam. And then the British took it over. That's what I said, and I referred to you the chapter in the history in the book, which says
that's
not my statement. I mean, this is completely, quite frankly, the website of the Assam government also says the same thing.
Anyway, I don't wish to join issue on that, my lord. But this was a wrong book my learned friend read. That's all I
kindly look at your own website. It says exactly that. Your own website. So let's not get into
anyway. Yes. Anyway, but I leave it at that. I don't want to embarrass Mr. Sibal.
What should just give me half a second. Just half a second.
Yes, Mr.
Only with permission of the Lord. The issue of, my lord, influx from Myanmar is separately, my lord, pending before your lordships. And there are other issues also pending, my lord. Therefore, I repeatedly, my lord.
Hegde also said the same thing that
yes, my lord, this is confined to the validity of 6A.
Confine ourselves to 6A, the validity of 6A, because
context of not being able to map the movement of population. That's all that I was saying.
All right. Yes, Mr. Diwan.
Since you
yes,
referred to the question of delay and lashes, I should have given your lordships a citation. Just because the principle is like this.
Yes.
If a wrongful act causes an injury which is complete, a damage arising out of the wrongful act, even continuous, will not be a continuous wrong. That is in 1959 supplement to SCR 476. 1959 supplement to SCR 476. Paragraph 39 of the judgment. What they say is there is a distinction between a continuing wrong and a wrong or a default, which is complete when it is committed. So 1971 Assam Accord. So complete when it is committed. This judgment has been quoted with approval in the Ram Janmabhoomi case. That is 2021 SEC 1, which is the Constitution bench.
2020?
2021 SEC 1. That's it.
Yes.
Namulas, may I just request you to take up the Citizenship Act, please? And with your permission, I will only make points and points in rejoinder. So I'll go point-wise.
Yes.
Now, the first set of points is on what I understand there's common ground, because we've now heard what the respondents have to say. So I think the first is quite obvious, that we are only concerned with Assam. There's a geographic limit. We are all agreed on that. The second point, as I took in the respondent's reply, it appears that it's now common ground that there's no temporal limit to the operation of Section 6A. The Solicitor General once mentioned transitory provision. I'll come to that separately. But 6A applies even to this day. It's not as if 6A applies and there is a cutoff date or a cutoff point of time. I think that's very, very important. You can make an application even today for the purposes of gaining a benefit under Section 6A. And I think that's very important. And it's common ground now that there is no, therefore, temporal limit to the operation of 6A. The third point which I wish to make, on which, again, there is commonality, is both sides are agreed that for the benefit of 6A, the notion of ordinarily resident in Assam is crucial and vital. There's no running away from that. Ordinarily resident in Assam is an embedded notion. As far as the statute is concerned, whether you're under 2, you're under 3, that's an important feature. And the final point which I want to make, on which I think there is now commonality, is with regard to the essential ingredients for the operation of 6A. Number 1, the person must be of Indian origin as defined. Number 2, she must come into Assam. Number 3, she must come from Bangladesh. And number 4, what I mentioned a while ago, must be ordinarily resident in Assam. These are the 4. So we are now all agreed on with regard to those essential requirements. Now please take up the Citizenship Act. Go directly to Section 6A. Now I'll just make my points. I'm focusing initially on 6A2. Please take up 6A2. First point, it's now common ground that there is no machinery for the purposes of evaluating, assessing, and determining the grant of citizenship under 6A2. No machinery. Now, notice, the legislature prescribes 4 criteria. Please take up 6A2. It prescribes the 4 criteria I indicated. It then provides no machinery for determining any of the 4 criteria, which is the person from Indian origin? Has the person entered Assam before 1166? Has the person entered from Bangladesh? And is he resident, ordinarily resident in Assam. There are 4 specific criteria. But these 4 specific criteria they are factual. To qualify under 6A2, you must meet these conditions. You must meet that's what the legislature says. But there's no machinery to determine these conditions. So what is the net effect of that? The net effect of that is, I believe this is a fatal flaw in the scheme. As far as 6A2, I'm only on 6A2 now. By providing, if you had, just take a situation, if you had not provided any criteria, then my submission would have been, this is completely void because you cannot distribute citizenship without rational, reasonable criteria. That's the foundation as far as the constitutional logic and the constitutional and good governance is concerned. There must be some criteria. To which the answer would be, but we have criteria. We have 4 criteria. But when you prescribe 4 criteria facially and do not couple that with a machinery to evaluate and assess those criteria, you are in short prescribing no criteria at all. And this is now fatal, according to us, as far as 6.2 is concerned. It just can't stand. You can't prescribe criteria, then have no machinery, and therefore just start granting citizenship. So now what's the net effect of this? The net effect of this is that any person, because it's 57 years now, since 1st January 66. So anyone over the age of 57 in Assam can claim citizenship without the requirement of establishing ancestry or provenance. That's the net effect. You are just, your carte blanche, just granting citizenship because you have no machinery. So basically what is happening is, this is the grant of citizenship without scrutiny. It is a criteria-less citizenship. 6.2, I'm only on 6.2. In effect, it is a criteria-less citizenship. And this, I don't believe Parliament can do, even though it has the legislative competence. No action under our constitution can be so completely devoid of any rationality or any basis. You prescribe it, all right, good luck, you prescribe it. But then what's your machinery to determine these 4 points? That the person has entered Assam, come from Bangladesh, is of Indian origin, which is defined, and is ordinarily resident in Assam. Nothing at all for 1st January 66. So I would respectfully therefore submit that insofar as 6.2 is concerned, it ought to go. That's all. I can't say anything further. It ought to go. You can't have a system of criteria-less citizenship. Facially, oh, we've got 4 conditions, but there's no machinery. That's the end of it. So this is now my first set of points. My focus was on 6.2. Now I move to 6A3. Sorry.
What would happen then is this, that suppose somebody is detected to be a foreigner.
I'll come to that. Yes,
suppose
yes,
he is detected or she is detected to be a prima facie a case of a foreigner.
Yeah.
Notice is issued to that person.
Yeah.
That person says that, look, I am protected by the deeming conferment of citizenship by 6A2. The onus was on that person then to establish that these 4 conditions were satisfied by them.
No, I am
so they have to then establish that, look, we must also understand that we are dealing with people who came in before 1966. That's why Parliament made this classification.
That's right.
But if notice is given to a person that, look, you are claiming to be under 6A2, but you have never come before 66. You are feigning something which you are not.
Yeah.
That person must show first entry before 66 or entry by an ancestor, parent, grandparent.
Yes.
To entry from Assam, 3 ordinary.
So let me answer that.
You know.
Let me answer that. Now I'm back. I'd moved to 6A3, but now I'm going back to 6A2.
This deeming conferment of citizenship.
Yes.
Is on those people who genuinely meet that description in 6A2.
True.
It does not confer citizenship on anybody who is just in India before 66.
But now, so let me answer that. Now let's focus on this and your lordship's point with regard. May I continue after?
Okay, continue.
No, what?
discharge because this will go.